Okay, well, we'll get started. Thanks, everybody. Thanks for joining us and for making the time out of your day and participating in our COVID-based webinar, along with some industry specialists who are here to talk to us about both COVID-19 and the impacts of that on the scheme, as well as the rest of the market and what the future could look like as well for return to work and return to office and considerations around the vaccine from an employment law perspective. So we're really looking forward to presenting that to you today. I'm actually joined by both experts in the nominal insurer space, so icare, and Moray Agnew law firm, who has kindly provided their time and insights from what they're seeing and recommendations that you can possibly take away from today. With that said, I'd just like to introduce you to a panel of our specialists. So we've got Michelle Dawson, who's a partner at employment lawyer at Moray Agnew. She's been providing specialist workplace-related legal services to clients in various sectors, and will be able to share her knowledge with us today. We also have Mary Musareska, who is the manager for the icare claims operation team and has been working in various operational and business-related roles within the industry for over 20 years. And lastly, we also have Joshua Richmond, who has also worked in the industry for many years and is now the technical manager and part of the COVID-19 response team across both the managed fund and TMF area of icare. So we're very fortunate to have them on board today, and we'll hopefully provide you with great insights and information that you can take away. The three main areas of focus that we'll be looking at, and the main purpose of this today's session, is to give you direct insight into the claim trends that have been experienced by the nominal insurer, what they're seeing from the Treasury managed fund space, and the flow on into the managed fund space. So understanding what that looks like and what that could mean for your business. Considerations for the mandating of the COVID vaccine, and we've seen examples so far with Qantas and Telstra and other businesses looking to mandate. What does it mean? Looking at the ombudsman and tiering of face-to-face client work and how you can best have that communication back within your business, and any relevant case law that's out there that could give us some perspective around whether or not there is a risk exposure for your business. And finally, just some general advice on how to implement those control measures and minimise that risk. So we'll go through that today. As part of our invitation, we encourage everyone to register some questions for our Q&A panel. So we'll do that after the first part of the session, and we'll work through that with the panelists. If there are any items or questions that you do want to ask throughout the presentation, there is a Q&A function. So I would encourage you to write that down if you haven't already had a chance before, and we'll look to try and address that if time permits towards the end of it. So yeah, I'll hand over to yourself, Mary and Josh, and get us underway.
Great, thank you. So we'll get started, and we'll just go through some of the insights we've noted for COVID-19 notifications across the scheme. Pandemic to date, we've seen a total of 846 notifications related to COVID, and this is spread across the nominal insurer and TMF space. These notifications are represented by both exposures to COVID-19, but maybe no positive diagnosis, a positive diagnosis claim, as well as stress and anxiety claims related to COVID-19, as well as more recently emerging some adverse reactions to vaccines. From here, we see the breakdown in terms of nominal insurer and TMF numbers. And you'll see next the types of claims that have been received so far. So far, the majority of the claims or notifications have been related to a positive diagnosis for COVID-19. Though that said, there is a growing trend towards vaccine adverse related claims, which is starting to emerge. We've had a fair number of psych-related notifications also, and these come from a varying degree of areas. So we get stress as a result of catching COVID-19 in the workplace, stress as a result of the accommodations that need to be made in the workplace to be able to continue to work due to COVID. And more recently emerging are stress claims relating to required vaccination.
And I also might add to that, thanks Josh, in relation to the diagnosis related COVID claims, we have definitely seen a trend formulating in the most recent quarter of this year to be more predominantly around those positive cases as well. So we're definitely, the claims that are coming through are those positive COVID-19 diagnoses that we see through the door.
Compared to this time last year, we probably saw more exposures or potential exposures than positive cases, whereas trending like the wider community, we're seeing a growing number of positive diagnoses from purpose of workers' comp. If you're happy to move on to the next slide, please. So here we've given a breakdown of the decision making that's been applied across all these notifications. You'll note, because this is live reporting, that we do have some there where liability is not yet determined. So when we prepared these slides, there were 2% of our notifications that were not yet determined because they would have just been received. But the majority are still reasonably excused. And often this represents a notification only. So there's no weekly payments required, and it's been the employer notifying of the potential claim. That said, we have a relatively even split between claims that get declined for whatever reason. So it might be it's a stress-related claim, and in fact, it's defended because it's been the way they've managed their employment and changes due to COVID, or there wasn't any proof that exposure happened at work. But then we've also got a number that are accepted or provisionally accepted, where things like the presumptive legislation that was introduced last year may have come into play to help connect the claim to, or the diagnosis to, their workplace. If you're happy to move on. Yep. And then with the emerging trends most recently in the space of COVID, we look at vaccine-related claims. So far for the nominal insurer, we have about 7 notifications related to vaccine-related claims. And these are spread across a number of different industries, but you'll note that the largest component of that relate to the health or aged care sector, which could be connected to public health orders that have gone out requiring people to be vaccinated. But also it could be an indication that these industries are earlier adopters of the policy around vaccination and their workforce. This represents currently about 2 or 4% of notifications. But if I look back about 2 weeks ago, the number of vaccine-related claims has doubled. So it's growing.
Great.
Yeah. And then if we move on to the next one. So in this slide, we've included some information around TMF claims. The reason for that is we've seen trends around vaccine-related claims a lot earlier developing within the TMF portfolios, and this is starting to move across into nominal insurer claims. So if you look, the other on this graph represents the adverse reaction to vaccines. So even though we don't have very many in the NI at the moment, we've got an area of our business where we're dealing with this already and looking to adopt practices and policies that might assist in addressing it from our experiences there. We've found that there were a number of government agencies that were likely earlier adopters of the mandatory vaccination programs, and that's what's contributed to this. So this is what we see, and this is what's coming. So I'm sure everyone has a little bit of, or some questions in regards to premium and COVID-19. So icare will continue to exclude costs related to COVID-related claims, and that's both COVID diagnoses as well as vaccination claims from premium calculations moving forward. There is work being done around identifying the right policies and excluding those costs, and this will happen over the next little while. You'll also receive information about this as the recalculation is applied. This is intended to protect employers who are disproportionately impacted by COVID-19. So particularly noting that there are certain industries that are more heavily impacted than others. And if at any point in time you've got any questions relating to this, just reach out to one of our underwriters who will be able to provide further information or some sort of reassurance in that space. Or alternatively, you can go to the resources that are on the next slide, the iHub, or find more information on our website in relation to COVID-19, which are all kept current and updated on a regular basis, and it should be an easy place to find answers to any questions that you might have. Thank you.
Fantastic. Thank you, Mary and Josh, for your insights on those. I would like to now hand over to Michelle Dawson to take us through some information on mandating the vaccine and what that might look like for employers and employees.
Thanks, Emily. Obviously, this is a particularly divisive issue at the moment within our society and within various communities, and we're seeing a lot of agitation around this issue at the moment. What we don't currently have is a body of case law that actually gives us direct guidance on exactly what it may or may not be safe for employers to be mandating or directing their employees to do. But certainly a topical issue for employers at the moment is vaccination and whether they ought to be mandating it. So a lot of this is at a high level for now while the law develops. The law is not often a fast moving beast, but the best guidance that is available at the moment around this is coming from a variety of different sources, and we'll talk a little bit now about that. But ultimately, what it boils down to is three particular circumstances exist in which an employer can require an employee to be vaccinated and also to provide proof of that vaccination, which is a secondary issue in many respects, but it is also an issue which employers are coming up against challenges around. The first of those circumstances is where there is a law or a public health order which essentially mandates it or gives a basis upon which employers can mandate vaccination. So an example of that is in June of this year when vaccinations were made mandatory for aged care workers. We are seeing healthcare workers come into that particular mix and border workers and those types of things as well. So essentially the higher risk the occupation, the more likely it is at the moment from the point of view of the status of the law and the public health orders that employers will be justified in mandating the vaccinations. The other circumstance is where an agreement or an employment contract includes provisions requiring vaccination. So that's a bit of a tricky one. I've worked in the area of employment law pretty much exclusively for the best part of the last 20 years, and rarely have I ever seen an example of an employment contract historically that actually mandates vaccination of employees, save and except perhaps for instances where different workplaces in different sectors are requiring the flu vaccine to be administered. And, you know, obviously aged care is among those by way of example, but certainly where employers are considering mandating vaccinations, where they do have an agreement or an employment contract in place which provides a basis for them to insist upon that, they will be better placed than otherwise in issuing that mandation. And the third set of circumstances is where it's lawful and reasonable to give a direction to be vaccinated. And this is where the law, in particular the law as it is developed by the Fair Work Commission around this, can provide some aid and some insight. If we can just flick on to the next slide there, that sort of brings us to the question of, well, what is lawful and reasonable in that context? And essentially, a direction will be lawful as long as there is legislation, a contract, an award or an agreement in place which makes it as such. Some of those things as employers we have control over, such as the contracts, as I just mentioned. Others we have very little to no control over in terms of legislation. Also there, of course, it's not quite to the level of legislation, but nonetheless it is a law, and that is the public health orders per se. So it will tick the lawful box where one of those things applies. But being lawful isn't enough. It also must be reasonable. And so one of the lenses that this is being looked at through at the moment is the safety lens, because obviously employers have obligations around providing a safe place of work. They are non-delegable duties and very significant responsibilities which employers have, not only for their employees, of course, but also for others that may be visiting their workplaces for whatever reason. And where vaccination is considered to be a reasonably practicable measure to manage the risks, then it will be more likely to essentially meet that test, so to speak. So the fact of the pandemic and the fact of the existence of COVID-19 alone is not enough to make it both lawful and reasonable to insist upon vaccinations within a workplace. Where, though, there is a risk of infection, so for instance, their border control, people working in quarantine hotels, whether they be working in security or in some other capacity across those jobs, there's obviously a higher risk of infection for those persons other than elsewhere within the community and in other sectors or places of employment. And therefore, in those types of contexts, the reasonable arm of that requirement is more likely to be met than where that sort of factor isn't present when we're asking the question. The other element around reasonable is, of course, where the employees come into contact with vulnerable people. So aged care is one example of that, as well as childcare, those types of occupations, health services, etc., as well. The other intervening consideration around all of this, of course, is the discrimination element. So when, as an employer, you are confident that you are in a decent position to mandate vaccination, you need to be very careful about the approach that you take in relation to doing that, because you may have within your body of employees with certain medical or religious excuses for refusing the vaccine. And to mandate something to someone which is essentially against their religion or which is contraindicative to some medical condition from which they suffer, you will put your business at risk in issuing that mandation. So it's very important to understand that even where you might consider your business to be in a position to mandate vaccination, there will be exceptions and other things to be mindful of in the course of doing that, and to issue the directive as a blanket type approach will present some legal difficulties. If we can just skip on to the next, thank you. There are 3 cases, and I'm not going to go into those particular cases in detail, but what I wanted to do was just give you a sense of where we're sitting in relation to the decisions at the moment, because it is all relevant to this issue of reasonable and lawful. And so each of these 3 cases comes out of the Fair Work Commission, and each is determined in the context where someone was required by their employer to be vaccinated, they refused vaccination, and their employment was terminated as a result of that refusal. What all of these cases have in common is that they were all determined in the context of mandatory flu vaccinations as opposed to a COVID vaccination. So whilst they are all cases from 2020 and 2021, we haven't yet, to my knowledge, as at this point in time right now, had a decision come down that is directly on this point in the specific context of the COVID vaccine. So the best guidance we can take at the moment is from the flu cases, and all of the considerations are in large part, I would suggest, the same, with the difference perhaps being that the flu vaccine, having been around for a bit longer, is more than just provisionally approved by the TGA, whereas the COVID vaccines, to my knowledge, remain provisionally approved. So there might be some technicality to be drawn when these principles are ultimately translated across by the Fair Work Commission or some other body in that context for that reason. But in large part, what the cases indicate is that there will be a liberal interpretation around what is reasonable, and that liberal interpretation will work to the favour of employers. So in each one of these cases, granted they were all determined in the context of interfacing with vulnerable persons, so one's in childcare, one's in aged care, one's in home care, but essentially each of the employers was found to have been entitled to have mandated the vaccine in the context of their business by reference to the particular risk that was posed by the situation. So a liberal interpretation of what's reasonable, but there are a couple of cautionary notes in that regard. Whilst a liberal interpretation has been applied and employers are essentially being given a wide berth around, when and where it might be reasonable, it's important to understand that the degree of risk that is posed and the industry that we're talking about is going to impact upon that. Another of the indications is that provided that the employers are not making decisions to terminate too hastily, so they're following a consultation aspect and a process, and provided that the employee, as a part of that consultation and process, is well aware of the possible consequences of them persisting in their refusal to be vaccinated, then the managerial prerogative of the employer to make the call about whether that employee remains employed will rest with the employer. In terms of working out how all of that translates across to each of your individual respective businesses and operations, helpfully, and if we could just skip ahead to the tier slide, please, Emily. The Fair Work Ombudsman has quite helpfully come out with this tiered approach where they have essentially categorised workers into 4 separate categories. Tier 1 is the most high risk category, and Tier 4 is the least high risk category. And what that means is that if your workers or any part of your workforce, doesn't have to be the entirety of your workforce, you might have 4 different tiers of employees within the one workplace. If the employee fits within Tier 1, it will be more likely that it will be reasonable to direct them to be vaccinated. If they are in Tier 4, it will be unlikely to be reasonable to mandate that they are vaccinated. So that is another reason why taking a blanket approach to mandating COVID-19 vaccines is a high-risk proposition for employers. Some of the larger employers that have come out and are mandating this, we've got the Qantases, we've heard the Telstras, we had SPC as a bit of a trailblazer in that regard a number of weeks ago now. Interestingly, each of those in large part sits, likely the principal body of employees sits within a different tier. So you would think, you know, Qantas employees might be more likely to be interfacing on a day-to-day basis than someone taking calls in a Telstra call centre, for instance. So there would be different levels of risk there. And no doubt Qantas and Telstra have been very, very mindful about the risk associated with a blanket enforcement of those requirements. So when asking yourselves the question, can we easily, readily, or without risk, perhaps, mandate vaccination for our workforce, it's really important to take a look at those tiers, ascertain where your people are most likely to sit within that tiered structure, and assess from that the degree of likelihood that it will be considered reasonable for a directive of that nature to be given, particularly where in your industry or sector there is no public health order that is imposed into the arrangement, making it a lawful scenario from that point of view. So some takeaways for employers other than that. It is really important to understand that the guidance from Safe Work Australia at the moment is that it is unlikely that that mandatory vaccinations is a required measure for the purposes of complying with one's workplace health and safety obligations under the legislation. And it's also made it very clear that a safe and effective vaccine is only one part of keeping workers and communities safe in all of this. The other control measures that the public health orders specifically give rise to around physical distancing, good hygiene, regular cleaning, mask wearing, etc., they are all additional and separate and available control measures that should still be being implemented regardless. And in many types of industries, they may well be enough in terms of managing the degree of control that must be exercised in terms of those control measures to ensure compliance. So, you know, we may get to a point where the Australian Health Protection Principle Committee actually is recommending vaccination for workers in specific industries and sectors. It's a good idea if you're thinking as an employer about implementing a mandatory vaccine measure that, pardon me, you keep mindful and keep a bit of an eye on whether that happens, because if it does, it will back you in from a reasonable and lawful point of view in terms of offering some protections around the potential risks for employers of issuing a mandatory vaccination directive. The public health orders, they're moving very, very quickly. They are changing almost daily. So keeping an eye on those and their expansion into different and alternative types of industries and workplaces or different categories of risk among employees. Another really important one is whether there is a risk of infection as a part of the work, the degree of vulnerability of people involved, the likelihood that it would spread, and then, of course, whether the requirement to be vaccinated is actually going to fall foul of any other obligations. Basically, you might as a business decide today that you don't think that you should, given the risk profile, and perhaps your employees are more aligned to tier 4 than perhaps tier 1, that there's a lot of risk involved for you actually introducing a mandatory vaccine protocol. But if at some point in the future, the location of your workplace becomes an area which has a heavy concentration of COVID-19 diagnosis and case instances, then that might actually change the position and the degree of risk which you take by introducing a mandatory vaccine protocol. So it's really important to just be aware of all of the things that are happening and all of the things that are introducing or extracting risk from the scenario in terms of your decision making as an employer around whether or not you should mandate vaccination. A really critically important one is most businesses will be the subject to either an enterprise agreement or an award in some way. Not every single employee might be subject to those employment instruments within a business, but the large majority will, and there is unlikely to be a single business that exists anywhere that doesn't have at least one award impacting upon the terms and conditions of employment within that workplace. And every award and every enterprise agreement contains a consultation requirement, and it is essential that if a mandatory vaccination policy is introduced, that consultation occur, as a failure to engage in a proper consultation process will render an employer in a significant risk scenario. So be very mindful of that. And where you do mandate it and you do get an application for exemption, perhaps from someone for whom it might be a medical contraindication for them to take a COVID vaccine. In the current environment, there might be a real supply issue prohibiting them from being able to get a vaccine. And also where there might be interposing religious circumstances where an application for an exemption is being made. It's really important to consider each exemption application on its own merits on an individual basis so that you can, as an employer, control your employment-related risk.
Thank you for your insights, Michelle. That was great. We will be moving on to the Q&A section of the presentation now, so I'll stop sharing the screen there. Now, we have received a number of questions, and I think it's important to note, Michelle, as you said, this is changing every single day. So I guess as the panel, if you're able to answer these to the best of your ability with the information that you have. First question to start with, this one is for yourselves, Mary and Josh. Are you seeing any particular trends where people are suffering anxiety because of fear of contracting COVID if returning to the workplace? And in addition to that, how can an employer work with the insurer to differentiate between the mental stress or anxiety associated with COVID versus just general work-related stress?
Right. I'm happy to jump in for this one, Josh, if that's okay. So definitely we are seeing lodgements coming through for anxiety around contracting COVID. It's definitely something we've also seen from the onset of the pandemic in 2020 and has recently dipped down in the NI space. We aren't seeing some large volumes, but although we are predicting that that could actually be something that we could see a bit more of a flurry from as the economy starts to open up. But in terms of that, the exact same legislative guidelines and principles apply to this. So, and in terms of determining liability, which is to really ascertain if there is a causal link and what is and how is employment the main contributing factor to the injury as well. So determining whether or not there is that causal main contributing factor and that link to employment. And one of the first things that I would definitely suggest in terms of working through how an employer and insurer can work through this together is to ensure that all appropriate information and as much information as possible can be provided to the insurer right from the onset, from lodgement, around the circumstances of the claim, any other incidences that may also have arisen, anything that could definitely contribute to making and deducing an appropriate liability decision as well. So all of the same facets of liability decision-making principles apply as they would for any other psychological claim as well. So there needs to be a diagnosis, there needs to be an evidence that there is that link to work.
Great. The next question, again to yourselves, Mary and Josh, will workers' compensation cover employees who may contract COVID whilst off-site for a meeting, for example, or even travelling interstate for work as well?
Oh, I might jump in here, Mary. So this would normally be handled the same way it would have been before COVID. If you're travelling for work and you can have a clear connection between what you're doing at the time and your employment, then it would be covered under workers' comp, just as if you had to travel interstate prior to COVID.
Great. fairly straightforward with that one. Thank you. The next one, Michelle, is for you. What rights does an employee have to refuse the vaccine if their employer mandates it?
Yeah, so look, that will really come down to whether or not the direction that's been given by the employer to get the vaccine is both reasonable and lawful. So essentially, if an employee decides to dig their heels in and not do as they're being directed to in terms of vaccinate, they essentially are backing themselves in that the Fair Work Commission is going to side with them and say that the directive that was given to them wasn't reasonable and lawful. And bear in mind, it does need to be both. So essentially, the employee, in backing themselves in that way, will be liable to termination if the employer believes that it's a reasonable and lawful directive and it's a directive with which the employee nonetheless chooses not to comply. Then the employee is liable to be terminated. The matter would then likely, if the employee is to take it on, end up before the Fair Work Commission in the context of an unfair dismissal determination. And the central question for the Fair Work Commission to determine in that regard will be whether or not the directive was reasonable and lawful. And then all of the things that we just spoke about will be taken into consideration in making that assessment. And if it is determined that it wasn't reasonable and lawful for the employer to have directed a COVID-19 vaccine to the particular employee, then the employer is at risk that the employee will be reinstated to their role and back paid to the date upon which their employment was terminated.
So those policies and procedures sound like they're quite key in all of this.
Yeah, I think so. Just really making sure that, you know, you're confident as a business that it is both reasonable and lawful to issue that directive, because the last thing you want is the one person to be ordered to be reinstated into your business, and you will see a flurry of additional consequences from a legal and possibly from a workers' compensation point of view from there.
Great. The next one I think was probably directed at you as well, Michelle, and I think this might link back into the tiers that you were referencing. So this one's specific to banking and finance. One of our clients has asked, what are some of the practices that you're seeing in banking and finance? And also, is the vaccination likely to be mandatory for sales and customer-facing roles?
Yeah, so this question really goes back to the tiers. Essentially, within a particular banking and finance operation, it is likely that you will have sales and customer facing roles within the business, and then you will have roles which are not customer or sales interactive. So that is going to mean that within that workplace, there are going to be employees that sit within different tiers. The employees that are in sales and customer facing roles are probably going to be at a higher risk of infection and will therefore be at the lower end of the tiering, and therefore it will be more likely that it will be reasonable to direct that they vaccinate, as opposed to some more backroom type workers who are not doing the sales and customer facing duties and don't have those types of responsibilities. They would likely fall back to a lower tier, in which case it would be less likely that it would be reasonable to direct those people to mandatorily vaccinate. So that's just another example of where a blanket style approach is not going to be ideal. What I'm honestly seeing in banking and finance at the moment, we've obviously seen some of the larger banks coming out and making available on-site vaccinations for their staff and the families of their staff in some instances as well. And what we're really seeing is those types of businesses using a carrot rather than a stick. So they are incentivising and making it readily accessible for their employees rather than necessarily mandating it. And what I suspect will happen is once they have been able to, using that carrot approach, get as large a body as what they're going to be able to readily get vaccinated, they will look at whether or not they need to then move from the carrot approach to the stick approach and start issuing directives around what particular employees in particular roles ought to be doing. So we're seeing a lot of incentivization at the moment and the increasing accessibility rather than any particular deliberate pushing towards vaccinations in some more direct fashion. And that is largely because we're not seeing any tier 1 type roles in a usual sense emerging in the banking and finance type industry, and those tier 1 categories are the ones where it is unlikely to be as risky to give that directive as what it will be for employees sitting in the tiers below that.
And just on that, Michelle, I mean, just going off script a little bit, a lot of companies are now looking to prolong the working from home arrangement and almost saying, well, no one's going back to work this year and we're going to look at next year. So that would obviously change or reclassify what tiering they fall under for now. Is that right? Is that what you're seeing from some businesses?
Yeah, absolutely. Particularly in that professional services realm or within those perhaps more highly skilled occupations within the banking and finance sector where, reasonably and practicably people can quite readily work from home to fulfill the duties of their roles. That is being regarded as the best essential control measure available to employers in terms of managing their risk. So where businesses, particularly, it varies across the different sectors and across different roles, but, most people as a product of 2020's debacle have worked out whether or not their productivity is truly negatively impacted by working from home arrangements. So where businesses have already worked out that their productivity levels are either not that much different or better, then they're going to be, and they're typically being more inclined towards continuing that type of arrangement, particularly while COVID is still circulating in our communities as rampantly as it currently is. And I think that we can expect to reasonably see that continue for some time yet, at least until businesses perhaps have the confidence that a significant number of their employees, we hear the government banding about 70% and 80%, and I think it changes depending upon who's telling you and what day it is. But essentially, I think businesses will ultimately start to do the same. They'll look at their workforces, they'll get access to the data to the extent that they're able around just who is vaccinated and what percentage that occupies, and make risk assessments around that. And it may be that businesses just decide that where an unvaccinated person can quite happily and readily and productively work from home, and they're happy to do so, that just may be the arrangement that stays in place for that person for the foreseeable future.
Thank you, Michelle. Last question from me before I hand over to Felipe for some further questions. This one's for Mary and Josh. So are there any plans or considerations being thought about for premium relief or support for particular industries that are unable to operate at the moment? Therefore, as an employer, they're unable to offer suitable duties to their injured workers, and therefore having to pay full compensation to those workers.
So there is a number of things that some thought has been put towards. More generally, there is relief being offered for premiums across the board. So for those who have had to reduce workforce or shut down due to COVID, the wages declared on policies can be easily updated to balance some of that out, as well as there is the option of refund of some unused premium. With that in mind as well, there's the work done around excluding COVID-related claims, both that are the illness or the diagnosis, but also injuries as a result of COVID-19. We're also doing work with our claim service providers, insurers, around more prompt response to circumstances like that, and working on better ways to engage in the space of, say, work capacity assessment to address the absence of duties being available, as well as compliance management where it seems appropriate. With those things in mind, though, there is another piece of work that we're still working on to get a little bit more concrete support that we might be able to offer. and that's a piece that's underway at the moment. So aside from those things, at this point in time, I can't share anything further beyond that.
Thanks for that, Josh. Just sticking with that theme, you know, disaster payments has been around for a couple of months, or at least 2.5 months now. How, when it comes to earnings, how is it being treated, particularly for injured workers who have been stood down and they're on, you know, working suitable duties full time and now have a full wage entitlement?
Yeah, so the disaster payments that are not actually considered as earnings, and workers or injured workers aren't mandated to also advise their insurer under the legislation to advise that they are undertaking or receiving the disaster relief payments. So it's not calculated as earnings, and therefore cannot be calculated as part of the POE piece as well. So it is actually rather different to the JobKeeper payment that was arisen at the onset of the pandemic last year as well. So it is definitely a different piece. Definitely a different piece of legislation, and definitely a different type of payment as well. Josh, you might want to add further to that piece as well, perhaps around what you're seeing in your space.
Yeah, so because disaster payments aren't being treated as earnings, it's where we've got that piece of work with our insurers really focused on better utilisation of the existing case management tools to minimise the risk that being unable to work represents for both cost of claim, but also premium that's being passed on.
So things like work capacity decisions, if we're getting into the technical side of things. Yeah.
Absolutely.
Yeah.
That's right.
And looking at maybe some less common ways of doing it that in the past. So in the past, there might have been an approach applied where suitable duties could never really be considered suitable employment for the sake of work capacity. Whereas now, if there can be some sort of indication that what they were doing as suitable duties could be available for the foreseeable future, this could represent suitable employment for the sake of a work capacity decision.
Mm-hmm. Yeah. Okay. That's good to know. So I guess just moving on with another question from our clients. So assuming COVID will eventually be treated like the flu, when somebody goes to work and catches the virus and they need time off for medical care, will an employee be required to take sick leave or make a workers' compensation claim? What are your thoughts on that?
This is very relevant and topical at the moment. We've commenced discussions with CIRA and Treasury around position on this. It is reasonable to assume that will be the eventual state that we end up at. But we can't talk about concretes at this point in time. We've got to look at what the impact will be, both from a scheme perspective, but also the wider community and the scale of COVID claims into the future. And then in turn, also the effects of long-term COVID. So there is some reasonable degree of certainty that it will eventually end up being managed more like the flu is now. But when that is a little bit uncertain.
Yeah, absolutely agree with Josh, and it really will depend on the public health orders at the time. You know, what the case numbers look like, the symptomology that's presented at the time as well, the vaccination rollout. There's a whole number of things that definitely would be at play, but I guess the important piece to note is that COVID-19 diagnosis claims or COVID-19 claims are definitely still compensable, and workers can still lodge a COVID-19 claim at this current time. And time will tell as things evolve, as Josh said.
And Mary, just on that, so we've just got another question from one of our clients on the call. Psychological claims, do they have a DSM diagnosis rather than stress? How is that being managed?
Yeah, look, great. That's actually a great question, and it definitely needs to be pertinent that there is a diagnosis, a DSM 4/5 diagnosis attached to injury. So again, like any other workplace injury, there needs to be a diagnostic approach to that, and there would need to be a diagnosis of something that falls under the umbrella of in the DSM-5 as a category.
It's worth noting from the stuff that we presented, we used the term stress to represent a cohort of a number of different diagnoses when it comes to claims. So you could have used stress or psychological injury as a result of COVID-19 when we're looking at the numbers that we shared earlier.
Mm-hmm.
And all of those principles, right from the onset of determining liability, that is exactly where deducing liability is really important, and that can really move a claim from provisional liability or to reasonably excused based on the medical information that's presented. Is there a definitive diagnosis of a mental health condition? It needs to be verified.
And with those particular claims or mental health claims relating to COVID, you had mentioned initially COVID claims were going to be non-premium impacting. So those psychological claims in relation to COVID, would those be non-premium impacting as well?
So if keeping in mind that COVID would have to be the main cause of the issue, those should be included in the review that's conducted for exclusion for premium purposes. There is clear guidance that we've provided our insurers around coding these claims, so we should be able to pick them up easily, and then that's where we will be looking to pull it out from claims experience as such.
Thanks, guys. One for yourself, Michelle. Can you include, so a few people have asked this, can you include a provision for vaccination for any new staff members commencing in a workplace in your employment agreements?
The answer is theoretically, yes, you can. Although you should be very careful in doing that such that the wording doesn't infringe those discrimination obligations and risks that we spoke of earlier in the piece. So if you were including a term, you would want it to be less than prescriptive from the point of view of, ensuring that there is an ability for people to make application for an exemption in certain circumstances, perhaps. But yes, it is doable, and where you have that, you will better position yourselves from the point of view of the determination of the question, is it both reasonable and lawful to have made that directive? If the employee knows, for instance, or the prospective employee knows, for instance, that as a requirement of them accepting this position, they must be vaccinated. And it may also be a case of not just requiring the initial vaccine, but also requiring the maintenance on an ongoing basis of the vaccine, noting that we're all of the understanding that a booster on a semi-regular, at least, basis, although the details remain to be seen, you would want to be ensuring that the wording of the term, in fact, traverses both the initial vaccine and the ongoing vaccine. And if you have that in place and the employee understands as a condition of taking up the employment that is going to be an obligation that they have, you will be better placed than otherwise to insist upon that term being complied with.
We have time, I think, for just one more question before we'll wrap up. Perhaps one for you, Michelle. I guess when employers are requiring evidence of the vaccination from employees, how should they best approach this? I guess keeping in mind the privacy of their employees as well. What would you suggest?
Yeah, so this particular issue opens up a whole foray of issues that really traverse around privacy laws specifically. But certainly, if it is a case that you need to have the understanding of the vaccination status of an employee so that you can assess and appropriately control the safety risk within your business, then requesting confirmation of the person's vaccination status might be justified. we will see pushback from certain groups of employees in that regard. And I hate to give a typical lawyer's answer, but it will really depend upon the nature of the issue that the employee takes on as to whether or not the request will be considered to be justified. We have had for quite a long time now employee record exemptions in the privacy legislation, which work to an employer's advantage in many respects across these things. At the moment, that exemption, as I understand it, does not properly extend to someone's vaccination status, unless perhaps you did have, looping back to the answer to the previous question, you did have a term in your contract that made it a term of the employment that vaccination status was vaccinated. That might change the position in that regard, but certainly what you will in large proportions find is that people who have a vaccination passport, to adopt the vernacular of the day, or otherwise have proof of vaccination, having been vaccinated, you as an employee will generally tend to be forthcoming with that information. It will be often those employees who aren't vaccinated or who were vaccinated begrudgingly that will not be so inclined to be forthcoming with the information. And where you end up in a dispute, it is really going to be a case-by-case basis around whether or not you can take the request for the information to an insistence for the information. So I would suggest that employers who find themselves in that situation should get very specific advice in relation to the circumstances.
Absolutely. And look, thanks for that, Michelle. And on that note, we'll look to wrap it up. I really just want to extend our gratitude and thanks to Mary, Joshua, Michelle, yourself as well, just on your advice and the knowledge and insights that you've been able to share with us and our clients and everyone on the call today. We didn't get to go through all of the questions that were asked, so we'll do our best to collate that and reach out to people specifically, or otherwise, feel free to contact, anyone from the Mercer Marsh Benefits team. The questions can be filtered back through us, and we can put you in touch with whether it be Joshua and Mary or Michelle or anyone else, should you have any, pressing questions or seek any further guidance and advice on these matters. But thanks everyone for your time. Have a wonderful afternoon and take care.
Thank you.